Good afternoon to those of you on the East Coast. Good morning to those of you here on the West Coast. My name is Priscilla Ochen. I'm a professor of law at Loyola Law School. I teach criminal law, race in the law, and critical race theory. Today that I'm honored to MC this press conference where the African American Policy Forum is joining the NAACP Legal Defense Fund to launch a campaign to demand the immediate repeal of the Trump administration's executive order on combating race and sex stereotyping, otherwise known as EO 13950. This equity gag order is a dangerous decree that threatens to undo decades of progress towards racial and gender equality. The campaign aims to push back against the White House attempts to silence speech that it deems subversive or un-American. Central to the campaign is the belief that honest discussions about racism, sexism, and structural violence are absolutely critical to build a fully inclusive democracy, and that these attempts to muzzle people having these discussions is unlawful, authoritarian, and reactionary. AAPF and the LDF are here today to illuminate why we should all consider this equity gag order to be extremely dangerous to American life, and to share the steps that we are taking to partner to begin to fight back. To begin, I'd like to turn this over to Janae Nelson of the NAACP Legal Defense Fund. Janae.
Thank you very much, Professor Chen, for that introduction, and good afternoon, everybody. I am Janae Nelson, Associate Director Counsel at the NAACP Legal Defense and Educational Fund, the country's first civil and human rights law organization. I want to thank you all for joining us at this press event to announce two important acts in service of the future and freedoms of our democracy. The first is the filing of a federal class action lawsuit against Donald J. Trump, United States Labor Secretary Eugene Scalia, and the United States Department of Labor. It is the first legal challenge to Executive Order 13950, also known as the Trump Truth Ban or the Truth and Equality Gag Order. The second event, as Professor Chin already mentioned, is the launch of Truth Be Told, a coalition-based campaign led by the co-host of this event, the African American Policy Forum, and its founder, Professor Kim Crenshaw. Truth Be Told is a campaign to fully and immediately rescind.
Hey, I just unmuted.
Hi, hello?
No,
Oh, sir, they see and hear you.
I don't hear them though.
Mr. Morial, if you could mute yourself, we're just in the middle of hearing from Janae. Thank you very much. Janae, I'll turn that back over to you.
Okay, thank you so much. I was describing the Truth Be Told campaign, which is a campaign to fully and immediately rescind Executive Order 13950, and importantly, to raise awareness for the need for even deeper and more robust engagement on issues of race, gender, intersectionality, and justice. I will begin by discussing the lawsuit and then turn it over to other speakers. The Legal Defense Fund is proud to represent two formidable and deeply respected institutions as lead plaintiffs in this historic challenge before the United States District Court for the District of Columbia, the National Urban League and the National Fair Housing Alliance. The National Urban League is one of the country's oldest civil rights organizations, and it has been at the center of the fight for economic progress for all Americans, and especially the Black community and other underserved populations. The National Fair Housing Alliance stands at the forefront of the struggle to eliminate the continuing scourge of housing discrimination in the United States and to ensure equal housing opportunities to all residents of our nation. And like hundreds of thousands of entities across this country, both of these organizations are federal contractors and recipients of federal grants. However, because of Executive Order 13950, their ability to contract with the government is in jeopardy if they or any subcontractor or vendor trains or engages their own workforce in what this administration has alarmingly defined as divisive concepts. Based on the administration's interpretive documents and the face of the order itself, divisive concepts can include discussion of common subject matter, such as systemic racism, and bias. It can include the acknowledgement of this country's sordid foundations in the enslavement of Black people, its past and current forms of gender and sex discrimination, and entire academic disciplines. This form of rank, speech, and thought policing directly contravenes some of the most sacred principles of the United States Constitution. Accordingly, the lawsuit that we filed today raises claims under the First and Fifth Amendments to the US Constitution. The First Amendment claim is rooted in the order's unlawful restrictions on protected speech in the form of viewpoint discrimination. Specifically, we allege that by restricting and limiting speech about specific topics and viewpoints and opinions and beliefs, the order violates the First Amendment's protection against viewpoint discrimination. The second claim is based on the vagueness of the order in violation of the Fifth Amendment of the Constitution, under which a federal law is unconstitutionally vague if it fails to provide a person of ordinary intelligence fair notice of what is prohibited, or if it's so standardless, as we submit this executive order is, that it authorizes or encourages seriously discriminatory enforcement. Our third and final claim is rooted in the equal protection component of the Fifth Amendment's Due Process Clause, which guarantees all persons equal protection of the laws and prohibits the government from treating persons differently on the basis of race, religion, national origin, or alienage. And there are many factors that point to the discriminatory race and sex-based motives behind this executive order. In terms of remedy, the lawsuit seeks injunctive and declaratory relief, most critically, an immediate injunction on the enforcement of the order. An immediate relief is necessary because of the threat that this order poses to the progress made and yet to be made in American workplaces. It seeks to deny the centrality of slavery and slave labor in the founding of our country, the history of Black codes and Jim Crow, and it would even stifle the ability to confront the underlying reasons that the current COVID-19 health crisis continues to ravage communities of color. It ignores the explicit and widespread sex discrimination against women and LGBTQ people, and it threatens to derail progress made by the Me Too movement by silencing training about sexual harassment in the workplace. It is also designed to stifle the fight for equal pay and diverse representation in corporate leadership. This could result in workplaces where people of color and LGBTQ people whose rights are continuously under fire from a range of discriminatory tactics are subject to racially hostile work environments or forced back in the closet. I'll close by saying that this executive order is nothing short of an authoritarian dictate to silence truth and denigrate equality at a time when our country is becoming increasingly divided by hate and ignorance. When millions of Americans across the country, joined by allies across the globe, have taken to the streets in peaceful protest following the tragic killings of George Floyd and Breonna Taylor, and are now speaking to one another across racial and ethnic and socioeconomic and even generational divides about the very truths that Donald Trump seeks to silence through this order. Both the form and substance of the order are a dangerous attempt to erase the lived experiences of women, people of color, and members of the LGBTQ community. It's an attempt to quite literally write them and their experiences out of our history by constraining the ability to speak about their history of oppression and ongoing systemic inequalities. This assault on the freedom of expression foments racial enmity and undermines the greatest strength of our country, which is our diversity. And while this is one of the most blatant missives against truth launched by the federal government that the Legal Defense Fund has witnessed in its 80-year history, it is sadly just another in the long line of attacks by this president on communities of color, women, LGBTQ persons, and any group that espouses views with which the president disagrees. From his Muslim ban to the ban on transgender individuals serving in the military, to his attempts to end DACA and add a citizenship question to the census, we have seen this playbook before. And as we have done now approximately 12 times since 2016, we have been forced to sue this administration again today in defense of truth and equality and fundamental tenets of our democracy. I'm joined on this video conference by our litigation team, our Senior Deputy Director of Litigation, Jinhee Lee, Senior Counsels Ajmel Qureshi and Monique Lin-Luce, Fried Frank Fellow Amber Kuntz, as well as our Director of Policy, Lisa Kyler Barrett, who has led our coalition advocacy, including a letter signed by over 120 civil rights organizations condemning this executive order. We are here to answer your questions after all of the presenters have spoken. And I now would like to invite our clients in this lawsuit, the National Urban League and the National Fair Housing Alliance, to speak next. Thank you for your time.
Thank you, Ms. Nelson. As Ms. Nelson said, we will now hear from the litigants to the suit. First, we will hear from Mr. Mark Morial, President and CEO of the National Urban League. Then we will hear from Lisa Rice, who is the President and CEO of the National Fair Housing Alliance. And then we will hear from Kimberly Crenshaw, who is the co-founder and executive director of the African American Policy Forum. Mr. Morial, I'll turn it over to you.
Thank you, Priscilla. And let me thank Janae for an excellent descriptor. And really, there's very little that we can add to what she outlined and what she explained. But I certainly want to thank the Legal Defense Fund for its incredible lawyering and its important work in this area, and certainly thank my co-plaintiff Lisa Rice and the National Fair Housing Alliance for all of their work. Let me just add a few thoughts, and then I will have to excuse myself because I'm in another meeting at this time. But first of all, this executive order is not worth the paper it's written on. This executive order smacks of a totalitarian endorsement of white supremacy. It smacks of what happens in places like North Korea and other nations that do not practice democracy or recognize individual rights and liberties, including freedom of speech. And this executive order seeks to chill the very essence of what the National Urban League was founded to do. And that is to promote truth when it comes to racial justice and racial reconciliation, and to be an advocate for this nation to confront its long history of racial exclusion, racial injustice, and discrimination and slavery and segregation. So we have joined this lawsuit because we feel we are duty bound to resist this executive order and what it represents, to resist it as an attack on our mission, on our work over 110 years, and seek to muzzle and gag our thought, our thinking, our voice, and our advocacy at this important time in American history. We work as a contractor to the federal government. And the essence of what we do is to seek to help marginalized communities, especially African Americans, to gain pathways into the economic mainstream of this nation. What we do is we work to encourage institutions, be they private institutions, public institutions, nonprofit institutions, be they businesses, government agencies, to embrace the notion of diversity, equity, and inclusion in all of their ways. So we have filed this suit, and as we do it, we are doing it on behalf of a generation on top of a generation of proud, strong men and women, our forefathers and our foremothers, both well-known and nameless, who have fought this fight over the years, and we will not we will not be silenced. We will not be silenced by this totalitarian abuse of power. Thank you.
Thank you, Mr. Morial, for those very powerful words. We'll next turn to another plaintiff in the suit, Lisa Rice, representing the National Fair Housing Alliance. Ms. Rice. Ms. Rice, you can go ahead with your remarks.
Thank you. I'm sorry, I was trying to unmute myself. Thank you so much, Priscilla. And I also want to thank LDF for all of its diligence in this matter. I want to thank our co-plaintiff as well and our partner in the fight for equity and justice and fairness, the National Urban League Markets. A privilege to be in this fight with you. The National Fair Housing Alliance works every day to fight all forms of housing discrimination. With our more than 200 members throughout the nation, we are working to expand equal housing opportunities for everyone. Trump's executive order is extremely dangerous because it seeks to erase the truth, to advance a revisionist, erroneous story about our past and our present. It's a blatant attempt to suppress the lived experiences of millions in this nation. But if we do this, we will only jeopardize our future. When my mother and my father purchased their first home, they wanted to buy a house in a community called Sylvania, Ohio, a suburb of Toledo. The real estate agent explained to my mother that not only would she not submit an offer to purchase the home on my parents' behalf, but she said she wouldn't even show my parents the home. She said that she would lose her license if she showed my parents this home because we were Black and because Sylvania was an overwhelmingly white community. The agent even told my parents that she would never be able to work again if she sold my family this home. Instead, she directed my parents to a neighborhood in Toledo that she said was changing. This was an area where Black middle-income families were being steered. Not only were we steered to this area, but when my parents went to their bank, the place where they had been banking for years, to get a mortgage loan, they were denied. Not because their credit was not good, their credit was great. They were denied because their banker explained that the area was changing and the bank wouldn't make loans in the area where my family was moving, essentially because families like ours were moving into this new area, it was being redlined. My parents had to get a subprime loan in order to purchase our family's house. So not only were my parents paying a really high interest rate, but their payment history was not even being reported to a credit repository, a credit reporting agency. They were impacted by a system that was making them credit invisible. When we moved into our home, we were the only Black family on our block. By the time I started kindergarten 4 years later, our entire community was almost 100% African American. As Black families moved into the area, the city's maintenance of the infrastructure lapsed, grocery stores left, insurance companies left, doctors' offices left, banks left. Our community became systemically segregated and disinvested at the same time. My parents' property value in that community where we lived in Toledo, Ohio, their property value didn't appreciate like the property value of the home they wanted to purchase in Sylvania, significantly reducing our family's net worth by hundreds of thousands of dollars. Still today, these two communities in Northwest Ohio are highly segregated. That community where I grew up in Toledo is still predominantly Black and disinvested. There are still no bank branches, no full service grocery stores, no doctor's offices or insurance companies. That neighborhood in Sylvania is still overwhelmingly white and benefiting from economic investments. What happened to my family happened to millions of Black and brown families throughout this nation. And in fact, as I'm telling this story, I see my colleagues nodding their head because I'm assuming that it's because they had the same experience that my family had. It happened to millions of people of color in this nation because of systemic racism and structural inequality. It wasn't a one-off. What happened to my family did not happen because of an individual act of discrimination. Our experience was not due to a bug in the system. My family experienced real harm because of structures, an interconnected, interwoven apparatus of racism, policies and systemic practices specifically designed to deny opportunities to people of color in this nation. This is the history that Trump wants us to forget. This is the truth that Trump wants to hide and obfuscate. Trump wants to perpetuate this myth that we have a racial wealth and homeownership gap in this nation because people of color are somehow at fault. People of color are making poor decisions, not because they are being impacted by systemic discrimination. Our organizations, the National Fair Housing Alliance, and our members across this nation, we enforce the nation's fair housing laws and we educate people in this country about them. Speaking the truth is what enables us to do our job. Recognizing what happened to my family and millions of other families and how systemic and structural inequities are still impacting families today, that is core to the ability of us to do our mission and carry out our work. Trump's executive order runs counter to this nation's values and stifles our ability to carry out the purpose of our fair housing laws. Education about racial and gender diversity, equity, and inclusion is necessary for the healing of this nation and to develop effective policies to overcome discrimination and structural inequity and ensure that everyone has access to the opportunities that they deserve. Residential segregation and racism are the bedrocks of inequality and negatively impact people's access to housing, fresh food, clean environments, credit, healthcare, employment, and other necessities of life. We cannot ignore this fact if this nation is to move forward. And that is why the National Fair Housing Alliance is joining with the National Urban League in fighting this equity gag order.
Thank you so much, Ms. Rice, for telling those hard truths, particularly about the experience of your family. Next, I'd like to turn it over to Professor Kimberly Crenshaw, the co-founder and executive director of the African American Policy Forum. After Professor Crenshaw's remarks, we'll open it up to questions from the audience.
Thank you, Priscilla. Good morning and good afternoon to all of you joining us for this important press conference. As Priscilla said, I'm professor of law at UCLA and Columbia Law School. I'm also the founding coordinator of the Center for Intersectionality and Social Policy Studies. I come to you today not just as a racial justice scholar, as a social justice advocate, or as a contributor to some of the ideas that are now ubiquitous in social justice and equal opportunity discourse. I come to you today as a concerned American citizen, observing daily an authoritarian effort to resolve our long journey to the promised land, to that idea of a more perfect union, by banning the distribution of knowledge about American injustice. Donald Trump's gag order rehearses an ugly history that those of us in the social justice world know all too well. It's an effort to purge and stigmatize anti-racist and anti-sexist projects by recalling strategies that sought to protect slavery, by criminalizing abolitionist literature, intercepting the mail, surveilling those who received those literatures. And what the laws didn't reach, mobs did, destroying printing presses, lynching authors and advocates, terrorizing those who objected to white supremacy, slavery, and segregation, forcing them into silence. The now lauded civil rights movement prevailed in spite of an ideology that described equality itself as un-American And in typical fashion, the targeting of racial equity was quickly followed by efforts to suppress programs that are intended to advance gender equity, LGBTQ inclusion, and of course, the intersections among them all. Make no mistake, what Donald Trump and his cronies are doing now is a massive attempt to repress equitable policies by muzzling efforts to talk about the sources and the consequences of inequality. Distilled plainly into the recent executive order, this is a Proud Boy dream come true, and we have to fight it. That fight begins by telling every American who cares about social justice that this order is coming for you. It's not just federal agencies, employees, and contractors that should be concerned at this point. It's every person who exercised their constitutional right to peacefully protest racial injustice this year. Every person who was saddened by the convulsive grief that fell over our nation after watching 8 minutes and 46 seconds of agonizing dehumanization. Every person who has been awakened to the nightmare of structural racism by the racially disproportionate death toll of the COVID crises. Every person who has been prompted to rethink American history, beginning with the institution that built the wealth of this nation. Every person who has witnessed the undeniable patterns of implicit bias by well-meaning colleagues who under-evaluate, overtalk, or mansplain them. Every person who endeavors to uncover the embedded inequalities in order to interrupt them. Every woman of color or any other employee who seeks to name the multiple forms of disadvantage that impact them, or any military officer, executive, or business owner who marshals the competitive excellence that equitable diversity delivers. This order implicates you. We cannot allow this detour to take us back down the twisted road to an unlivable past. So that battle begins in earnest today. We are proud to stand with the venerable Legal Defense Fund as they take this fight into the courtroom. And we know that this battle, like all equity struggles that have brought us here, will stretch beyond the courtroom, will stretch beyond this case. It will require the collective efforts of all of us, an effort that is expressed by a broad network of civil rights, social justice, educational, diversity, and business organizations that have opposed this ban. Those groups include the U.S. Chamber of Commerce, the Association of American Colleges and Universities, the American Hospital Association, the National Association of Manufacturers, the Business Roundtable, and more than 120 other business, civic, and academic groups. Joining them are leaders in higher education and more than 4 dozen other groups representing colleges and universities across the country. Even with this formidable alliance, the AAPF has collected hundreds of stories from across the US about events being canceled, research dollars being withdrawn, trainings being indefinitely postponed, and speeches being canceled. The censorship detailed in the hundreds of responses we received in just the first few days of this order hardly addresses the self-censorship that goes beyond those directly affected. Many of the people we've spoken to have been frightened to publicly share their testimonials and identify their employers and clients for credible fear that reprisals in this chilling atmosphere are destined to happen. To wit, the executive order has created a snitch hotline to encourage those who oppose equity projects to lodge complaints that would lead to investigations. One can only wonder where we would be as a nation had such aggressive efforts been made available to enhance equity rather than stunted. Truth be told, what we need is not a snitch line, but an equity hotline. We need to know when our efforts to do better are being shut down, by whom, and to what effect. We ask you to join us in our efforts to learn more about the impact of this order and to demand that the whole truth be told. We know that the attacks against the discussion of racism, sexism, and structural violence won't go away easily. We're going to have to stay vigilant and stay aware of attempts to silence this kind of speech wherever it occurs. We need help by continuing to share if and how this gag order has impacted your job, your workplace, or your community. You can join us by completing our survey at bit.ly/equity gag order. I'd like to close by invoking Martin Luther King Jr.'s speech in the March on Washington in 1963, where he passionately asserted that America had defaulted on its promissory note, that when the oppressed in this country went to cash a check for freedom and civil liberties, that check came back marked insufficient funds. The Trump administration's recent equity gag order is not only rehearsing the insufficient funds that have long plagued the most marginalizing, it has actually tried to take that check and rip it up. We cannot allow Dr. King's dream to end at such inglorious hands as those of a president like Donald Trump. Join us in this struggle. Join us in this fight. Thank you. Priscilla?
Thank you very much, Professor Crenshaw, for those powerful words. I'm now going to open up the press conference to questions. For those of you who are joining us via Zoom, you can use the raise your hand function, and I'll call on you. You'll be permitted to speak. You'll be given permission to speak through our audio system. And for those of you who are joining us via Facebook Live, you can type your questions into the chat function and they'll be communicated to us, and I'll ask them to the panelists. So for those of you who have a question, just go ahead and raise your hand. Let's see, we have a question from Emily Peck.
Hi, can you hear me?
Yes, we can. Please.
My question is the timing with the elections just, less than a week away. There's a chance that this administration ends and a new administration comes in. So was there talk about waiting until the election results are in, or was this just simply too urgent and had to be done sooner?
Yeah, I'm happy to respond to that, and we can respond in two parts about the lawsuit and about the campaign. I'll start with the lawsuit. As you said, this is far too urgent for us to wait until the outcome of an election, and primarily because the outcome of the election will not, in and of itself, rescind this order, no matter who is elected. This is an executive order signed by a president that will stay in effect until it is rescinded either by him or by his successor. And as Professor Crenshaw has already outlined, the havoc that this executive order has already wrought on workplaces and federal contractors and vendors and subcontractors across the country is devastating. There's been a widespread chilling effect even among those who may fall outside the immediate scope of the order. We are seeing trainings being pulled down. We are hearing employees who feel that they are no longer welcome in their workplaces, that the tenor and tone and climate of workplaces has been transformed overnight. And so it is imperative that we come out in full force, objecting to not only the issuance of this order, but the widespread effect that it has already had. And even if it were rescinded tomorrow, there would still be a lot of rebuilding to do to restore the momentum towards equity and diversity and inclusion that was already in play before this order instituted and instigated a very chilling effect. We also know that with any subsequent administration, there will be a number of priorities for that administration to address. And we want to ensure that this is among the top, if not at the top, because of the message that it sends, as Mark Morial already underscored It is a very transparent endorsement of white supremacy, which has no place in our modern democracy and needs to be eradicated immediately. So the urgency could not be overstated, and that is why we filed this lawsuit. We're also a nonpartisan organization, and so our focus is not on who is winning on Tuesday or following Tuesday, but more so on ensuring that we protect the constitutional protections of all citizens of this country.
Thank you, Janae. I will just add to, I think, everything that Janae said, to remember that it takes decades, if not centuries, to build the equity practices that we have now. It's taken and can take a week, a month to tear those down. So timing is of the essence. We cannot wait for an election. We cannot wait for an inauguration. It is important that we start the process of making Americans aware of the destruction that is happening as we speak. That is like a fire that's happening right now. We wouldn't wait to see what's going to happen in a few days before we sounded the alarm if it was a forest fire. What we are facing right now in terms of racial equity and gender equity is that forest fire. So we need to attend to it immediately.
Thank you, Professor Crenshaw. I'm going to take the next question, and Cheryl Harris has our next question.
Thank you. Can you hear me?
Yes, we can hear you.
Well, we understand that the executive order is directly targeting anti-racist ideas and speech, but I wonder if someone could speak to how the order affects LGBTQ communities and advocacy on their behalf, and particularly considering the way in which the administration has already targeted trans individuals. Thank you.
Thank you very much, Cheryl. It is absolutely the case that this order, while it's being framed by the administration primarily as a response to racial equity policies and training and knowledge, it also applies by its own terms to gender-based trainings and has been interpreted beyond that to apply to a broad set of justice-oriented programming. One of the respondents to our survey, Sterling Cruz Hare, is the founder of TransClue. It's a transgender-owned training and consulting company. And they offered a statement on the impact of the equity gag order on their work and on their community. I'm not sure if Sterling is with us at this moment, but Sterling in their statement pointed out that that a training that they were going to do was canceled the day after Trump had talked about the Proud Boys. And I think what's so powerful in their statement is it struck me so profoundly that these days only Proud Boys are the ones allowed to have pride. So it's important, this is a wake-up call, that this impacts all of us. We all need to be at the table on this. We all need to lean in to this effort to rescind the order. And I would dare say beyond that, to make it clear that our Constitution is not neutral on racism or anti-racism. It's not neutral on sexism or anti-sexism. It's not neutral on discrimination against queer people, non-binary people, and trans people. Our Constitution takes a position, and that position is equality. So speech enhancing this mission can't simply be thrown away because it offends the sensibilities of some people like President Trump.
And let me just also add that it's not as if this executive order itself is race or gender neutral. In its preamble, which frankly is a manifesto for white supremacy, it clearly favors and attempts to carve out protections for cis white men. It says, in particular, it contests the idea that there should be any discussion or discourse about the notion that the United States was founded by white men for the benefit of white men. That is an incontrovertible statement. If you know anything about the history of our country, if you look at its founding documents, and if you understand the origins of this country and the genocide and racial subjugation that is its floor. So it is not even our notional inferences about what this executive order intends to do. It is actually in the text and the preamble of this order that we see the favoritism toward cis white men, and that is one of the bases for our Equal Protection Clause claim in the lawsuit.
Thank you. And we do have Sterling here with us. So Sterling, would you like to add to anything that Professor Crenshaw said?
Sure. I just say that when Professor Crenshaw talked about how long it takes to build up these equity structures, the Environmental Protection Agency had a group of LGBT employees that had started organizing Pride before COVID struck, and they spent months and months pulling people in, practicing, promoting the event. So there was all this momentum around this, only to find out that the event was canceled. And so I think that I didn't come forward with this. The story just kind of got leaked because I was afraid for the employees that were organizing it. That's how chilling it is. And I couldn't agree more that the time is of the essence in determining how to deal with this and fighting it in the way that these two very powerful champions are doing with this lawsuit.
Thank you, Sterling, for sharing your experience. Our next question comes from Alexandra Olson. Alexandra.
Hi, yes. My question was about the National Urban League, a mention in the lawsuit about a contract that the Urban League has that is set to expire in December 31st, even though there was an option to extend it into next year. The lawsuit says that this decision to only extend the contract until December 31st came around the time that executive order was issued. So I just wanted to get a little clarity on that. Does the National Urban League feel that this decision on the contract was because of this order, or is it somehow related to this order, the decision not to extend the contract beyond December 31st?
So I believe Mr. Morial is no longer on our call, but I'll open this up to any of the other participants. So Janae, Professor Crenshaw, Lisa, if you all would like to respond.
Sure, I'm happy to start, and I do want to invite Ajmal Qureshi and Monique Linloose and Jin Hee Lee to weigh in from our legal team if they would like to answer in more detail. But in essence, we put those facts into the complaint because we thought they were absolutely relevant to understanding the broader implications of this executive order and the inferences that can be made from the administration's actions, both in relation to the order and in relation to how it has treated federal contractors and has treated the prioritization of diversity training in its federal contracting. We think it's all of a part. We think that these actions are all interrelated and are part of a broader effort to stifle the very knowledge that we've been speaking of, and the truth telling and the history and the efforts to ensure diverse and inclusive workplaces. So we see these efforts, the failure to extend the contract, the failure to continue what was a robust relationship supporting training that dealt with diversity and inclusion as a manifestation of the ills of this executive order, even if the executive order had not yet been issued. This was a foretelling of the shape of things to come.
Thank you very much. The next question is from Cheryl Estrada. And Cheryl, if you could please identify yourself in terms of the news organization that you are with. Thank you. It doesn't look like Cheryl was able to speak. So I'm going to pose a question that was asked in our Q&A box from Kimberly Hauser. The question is, do you have a sense of how the new composition on the Supreme Court would rule if the class is not certified, or whether you have a sense about whether the executive order is ruled unconstitutional based on their previous decisions, either the U.S. Supreme Court or the Ninth Circuit? And I see Cheryl's here, so I'll come to you in just a moment. So if you want to respond to the question from Kimberly, which is about how the new composition of the court might affect a decision on the lawsuit, or how the lawsuit will be treated in the courts.
Sure. So the Legal Defense Fund has had a lot to say about the current composition of the court and the processes that have led to it. And we've issued a report, which I commend to anyone who's interested in understanding our position. It's posted on our website, and it's a report concerning the proceedings and processes that led to Amy Coney Barrett's nomination and confirmation to the Supreme Court. I will say, with respect to this challenge, like so many others that we've been involved in with this administration, the infirmities of this executive order are so acute. The overreach of this order is so extensive. The violations are so blatant that we expect any court, regardless of its composition, regardless of what many may ascribe as its ideology, to see this for exactly what it is, which is a gag order on truth and equity, which is a direct affront to our freedoms of speech and expression, and that any court, any judge or justice that has any fidelity to the Constitution would also see it in that same way and immediately grant the relief that we've requested.
Thank you. Our next question comes from Cheryl Estrada. And Cheryl, if you could tell us your affiliation, please.
Yes, I work for a media company called Industry Dive, and I specifically write for a publication called HR Dive, dedicated to human resources. So the question falls around, following the killing of George Floyd, there have been subsequent increases in racial diversity trainings at private companies. HR departments are actively doing that. So I just wanted to hear your perspective on the implications that this executive order will have on the private sector.
Kim, do you want to take that?
Well, thanks, Janae. I will say that from the information that we've been receiving, the impact for many employees who are in private sector companies is both chilling for those who don't have to worry about direct federal contracts. So to state it in another way, because so many companies are worried about the eventual impact of this order, some of them are taking prophylactic measures to shut down training or anything that might eventually come into the crosshairs of this administration or any other subsequent effort to enforce this. The other thing that has to be remembered, though, is that the notion of private sector, when we're talking about governmental grants, is really small. In other words, many private sector companies have or hope to have relationships with the government, hope to have contracts. And so those who have contracts and those who hope to have contracts are obviously caught in the crosshairs of this. and have subsequently considered whether their programs might run afoul of this order. And let me say this as well. Janae was quite right to say that the order is so broad and so vague that there really is no way to protect against it, because what it is saying is almost incomprehensible. So for many companies, the safe path is just to eliminate all conversation about race and gender equity. And some of them, unfortunately, have decided to do that. And one can only wonder if this is part of the intent, to say something so broad, so wide, that people would rather not take up the issue at all. But I'll turn it back over to the LDF to speak more directly about the terms of the order, how far it reaches.
Yeah, I want to jump in to just chime in there, because the point that you raised, Kimberly, is really important. The National Fair Housing Alliance, we have a very extensive training and consulting program. So we do provide a lot of consulting and training to financial services institutions and to companies in the housing sector. And so one of the things to keep in mind is that many of these institutions are regulated by federal agencies. So when you're talking about financial services institutions, they are regulated by their prudential regulators, who are subject to this executive order and are impacted by either directly or indirectly, as Kimberly was describing, by the executive order. And so we have had a number of very clandestine, confidential conversations with industry stakeholders who are concerned about negative fallout if they proceed in a very public fashion with some of the racial equity initiatives and efforts that they wanted to undertake. So in the aftermath, if you remember, of George Floyd's murder, you saw a number of institutions come out and make public statements about racial equity and inclusion, and announcing that they wanted to undertake really extensive and comprehensive programming and investments to address racial equity. And we are hearing from some of them that they are getting calls and questions about the way they're phrasing things and the way they're saying things, and how they're describing the programs that they want to undertake. So yeah, this is definitely having an impact, which is why it is so critically important for us to make sure that this gag order is stopped, so that organizations who have made public commitments to invest deeply in racial equity programming and initiatives will be able to fully proceed with their efforts.
Thank you. So we have some questions from our viewers on YouTube and on Facebook. So I'll read those off, but I'll also say, just as a reminder, there are folks who are participating via Zoom. If you'd like to ask a question, you can use the raise your hand function. So the first question is from Joy Schaefer. Joy Schaefer's question is, does this executive order affect only public institutions, universities, or will there also be a trickle-down effect on private colleges and universities? So I will perhaps direct that to Janae Nelson from the Legal Defense Fund.
Sure, so that's a great question. And there's been a lot of question about how far-reaching the order is and exactly who it implicates. There are clear restrictions on what, for example, military academic institutions can do under the order. There are some very nebulous terms, which is one of the bases for our challenge, about ways in which it technically should not apply to academic courses, but that's only if those academic courses teach the material in an objective fashion. So that measure is anyone's guess in terms of how that might be enforced. So we do think there is potential exposure for public institutions and for private institutions that receive federal funds. I think Kim put it best in her opening remarks when she said that this is not just about federal contractors. This is not just about vendors and subcontractors and even potentially federal grantees, that this order potentially comes for everyone. This is ultimately thought and belief control. It is knowledge policing. It is a clear and direct authoritarian dictate on what we can think and believe. The very terms of the order prohibit thoughts and concepts and discourse that may make people feel uncomfortable or feel a certain amount of anguish, which immediately takes, in my mind, almost any discussion of race that grapples with the deep entrenched history of it in this country off the table, because those conversations are necessarily anguish producing to get us to a point of progress in this country. So the terms of the executive order themselves are expansive and deeply concerning and do touch a number of entities and institutions, including potentially academic institutions, both private and public. But it is essentially an alarm being sounded as to what we might expect to continue and to broaden if this executive order is unchallenged.
Thank you. And I also want to turn it over to Jen Lee from the Legal Defense Fund.
Hi, as Janae Nelson had just said, the scope and the how broad this executive order is really quite alarming. It's not only public employees, but also federal contractors, but not only just federal contractors, it also applies to subcontractors and vendors whom the federal contractors may have agreements with. And then of course, there are all the entities that receive federal funds through grants that may be implicated by this executive order. So the scope of the effect and the impact of this executive order is almost unimaginable when we think about how many entities, whether they're private or public, have some sort of connection with the federal government. And that is why this executive order is so alarming in terms of its breadth.
Thank you. Our next question comes from Facebook, Camille Wise. Camille's question is, in addition to challenging legislation, do we as CRT practitioners adapt to do we adapt the language of our curriculum in the interim? Camille is interested in some tactics to maintain the integrity of trainings that use systemic racism and CRT as underpinnings while still adhering to the executive order while it exists. I don't know if that's a question that you can take at this point, but I'll turn that over to perhaps the folks at LDF or Professor Crenshaw, if you'd like to comment.
Well, you know, I will say that the breadth of the order is so challenging that I'm not even sure that the tactics that some people are taking are really sufficient. So obviously, one of the most immediate things that some people are doing is going through their slides, or I should say that some of the reports that we have gotten tells us that administrators have asked for slides and asked for speeches, and basically taking a red pen and eliminating words like structural racism, critical race theory, intersectionality, implicit bias, all of the terms that President Trump has used to say that these are the things that are basically racist. It's the old ploy of saying that the first one to talk about racism is the racist. This is racism through using the same kind of frames that have been used wrongfully against affirmative action. So is there a way around it? Can you talk about structural racism and not use the term structural racism? Can you talk about intersectionality and not use the terms intersectionality? Can you talk about implicit bias and not use the term implicit bias? Well, let me say that even in the executive order, they're smart enough not to use all of those terms, but to say that the feelings and the messaging and the viewpoint that those ideas represent are themselves what is being prohibited. So I think people are going to try to adjust the best they can, but recognize that until this executive order is history, and until we actually create affirmative requirements, affirmative expectations that to really be an equal opportunity employer, you've got to teach people about the sources of inequality. And until that happens, we're going to be in a rear guard action. And that's why all of the different dimensions of equity, policymaking, education, research, and advocacy have to come together and fight this order. It will burden every aspect of this work if literally we are being muzzled and are unable to share the knowledge that people have so painfully made available and accessible to us over years of social justice advocacy, research, and scholarship.
Priscilla, I think this is a fascinating question, and it's actually thinking about questions like this that made me structure my comments the way that I did, rooted and embedded in the story of my family, which is a true story. It is what happened to my family, and it is still obviously impacting us today. And it is again why I think that this executive order is so dangerous, because it seeks to strip away the real stories of our lives and strip away our ability to talk about how these experiences are impacting us and our children and future generations. So I will leave it there, because I'm not a lawyer. I'm not trying to give anybody any legal advice. But I will say that my story is my story, and no one can take that from me.
Thank you very much, Lisa. We have another question from Emily Peck, and I neglected to ask this last time, but can you state your affiliation, please?
Yeah, hi. I'm with HuffPost. I'm a reporter at HuffPost. I just had a process question. I didn't catch what court the case was filed in, and I wondered if you could make the suit available to us on the call, or if it's posted somewhere already.
Absolutely. It's filed in the district court of the U.S. District Court for the District of Columbia. And we can certainly post, I believe, I'm speaking on behalf of my team here, but we can post the filed complaint in the chat, or certainly make sure that you get a copy. And it should also be on our website, naacpldf.org.
Thank you.
Sure.
Thank you.
All right. Again, I will just do one last call. If folks have questions who are attending via Zoom, please raise your hand. We have one last question from YouTube viewer. The question is, how are professors supposed to provide diverse perspectives on the U.S. struggle for race and gender equality if this executive order can punish social justice professors for doing their jobs?
Yeah, that's an iteration of the last question, and really underscores how it frustrates the mission and purpose of entire industries. And I would include in that our two plaintiffs, our two named plaintiffs, whose missions would be frustrated by compliance with this executive order. It also really puts people between a rock and a hard place, including disseminators of information like professors, people who are charged with educating and challenging our beliefs and assumptions about others, and leaving them without the tools to do that effectively and to do that honestly. with a real reckoning about the facts, with the facts of our history. And it brings me back to the previous question about what employers can or cannot or should not do. And while we cannot offer legal advice, it's important that I at least flag the potential danger in dialing back trainings to become so watered down that they are ineffective. While many may critique the efficacy of diversity and inclusion trainings and whether they are as robust as we'd like them to be, there's lots of debate about that. I think the one thing we can all agree on is that having these conversations in the workplace has been transformative in many ways. It has created a more inclusive environment. It has at least opened the door to be able to raise these issues. Mandatory sexual harassment training, for example, has educated many workers about conduct that they may not have otherwise understood to be inappropriate. And employers operate at their own risk if they start to dial back these types of trainings to such an extent that they don't properly educate their workforce and then wind up liable for the harms and violations that may result from that lack of information. So it's a very difficult position that this executive order puts employers in and puts potentially, others who need to disseminate this type of information in, which is precisely the reason why we are challenging this executive order. It stands to produce such devastating harm in the workplace and beyond that it must be challenged and it must be pursued aggressively.
Thank you, Janae. So it looks like we have exhausted all of our questions. So at this point, I will just do a quick round robin to see if any of our participants have any closing remarks, and then we will conclude the press conference. So I'll start with Lisa. Do you have any closing remarks for our guests?
Thank you, Priscilla. I just want to thank LDF again for its leadership on this issue. They have some of the best lawyers in the world, and we are distinctly privileged to have them representing us in this matter. We are humbled to be joining our colleague, the National Urban League, with whom we have been in the trenches for decades, addressing fair housing and fair lending issues. And I also want to thank Kimberly Crenshaw and her team for this amazing challenge and public education campaign. It is so critical that we provide the public and we provide people with the tools and instruments that they need to effectively talk about this harmful rule and explain how dangerous it is. I was just having a conversation with my son and his friends in college last night about these issues. And so helping to have these tools to give people, empower people with the right messaging and information is so critically important.
Thank you, Lisa Rice. Next, I'll turn it over to Janae Nelson. Do you have any concluding remarks?
Thank you, Priscilla. Thank you so much. I'm so glad that we were able to do this forum today. And I want to thank our legal team who has toiled so feverishly to file this incredible complaint and to be the first to challenge this executive order. But my thanks really go to our two anchor plaintiffs, the National Fair Housing Alliance and the National Urban League. As you've heard, there are so many institutions who are nervous and scared and frightened about the implications of this executive order. And the Legal Defense Fund has had the privilege and honor to represent clients who have been courageous to speak truth to power. And in this case, truth is what this is all about. And who have been willing to do that in the face of scrutiny and in the face of uncertainty. And while everyone is not in a position to do that, it takes the leadership of organizations like the National Fair Housing Alliance and like the National Urban League to stand in the shoes of those who can't stand up for themselves and to be those representatives in this fight. So we are very grateful for their willingness to pursue this challenge with us. And we are also incredibly grateful for the partnership of the African American Policy Forum because it does take a full, multifaceted, cross-sectoral campaign, not only to understand this order, but to also use it as an instrument to raise awareness for the increased need for robust dialogue around race, gender, justice, and equity in this country.
Thank you. And last but not least, Professor Crenshaw, one of the co-founders of critical race theory. Do you have any closing remarks?
Well, thank you. Thank you, Priscilla. I have to say that when I first found out about this pending order, I got an email from one of my colleagues, Chuck Lawrence, who said something to the effect that those of us who've been doing this work must be doing something right because people want to shut it down. And I can't be more proud to be standing with 3 organizations that have been doing something right for the equivalent of centuries. The fact that they have stood in this moment and have been willing to say what so many people have been saying in private, but for reasons that Janae spoke to, were unable to do so, just gives everyone a sense of how serious this gag order is. This isn't just something that the Trump administration just, thought about, dropped it, and moved on. This is a bomb in the middle of social justice advocacy. If you take away the ability to name a problem, you cannot solve it. Why fight about remedies? Why fight about cases and approaches when you can basically silence all conversation about the problem? And the reason why I think it's so important for people to understand that this is part of our history is that there was a moment in history where this worked. There was a moment in history where shutting down all advocacy around abolition actually worked. There was a period of time where shutting down the efforts to fight against segregation worked. There was a time when white citizens councils used all of their power in order to shut down the work that Thurgood Marshall was doing, in order to shut down the possibility of creating fair housing, in order to shut down demands for equity in employment and in criminal justice. It is because we overcame those efforts to shut down advocacy and discourse that we are here today. And frankly, this is a moment where Americans want to know more about their history. Their eyes have been opened by the 1619 Project. Their hearts have been opened by what happened to George Floyd. So this is a response to that opening. This is the counter to the energies that have erupted in the last 6 months. So it is up to us to keep that fire for knowledge, that quest to know more in order to do better, to create the kind of country that we want to become. We can't get there by closing our eyes. We won't get there if our tongues are ripped out. So what we have to do now is come together in every way we can. We have to support this case. We have to create the knowledge base so we know the depth of what's happening. We have to tell the truth about diversity. We have to tell the truth about implicit bias, intersectionality, 1619, critical race theory, not allow the distortions to undermine the knowledge that has gotten us to this point. So I want to thank Janae Nelson, her colleagues, at the LDF for taking this up. I want to thank the amazing plaintiffs who have stepped forward. I want to thank all of you for recognizing that even though we're in the middle of a presidential campaign, this is one of the most important issues of our generation. So thank you for joining us.
Thank you very much, Professor Crenshaw, and that concludes our press conference. If you'd like to follow the discussion on Twitter and on other social media platforms, you can follow in the hashtag #TruthBeTold. You can see here the various handles on Twitter for our participants to continue to follow this conversation. Again, this is about structural racism, being able to name problems and solve them, but it's also about intellectual freedom. It's about free speech, and it's about our ability to speak truth to power. So thank you all so much for attending. Thank you to our participants. And again, that concludes our press conference. Good afternoon.